Hello, I'm honored to have here today Mr. Giorgio CORNO, President of INSOL Europe, the insolvency practitioner organization at the European level. Giorgio is also a lawyer, solicitor, founding partner at Studio Corno Avvocati, Italy. He provides corporate and litigation services, mainly in the area of corporate and commercial restructuring. He regularly advises domestic and international clients with a specific focus on cross-border issues. President of INSOL Europe for 2023-2024, Giorgio is also a conferee at CERIL, Conference of Europe Restructuring and Insolvency Law, International Insolvency Institute, European Law Institute, and International Law Association. He frequently lectures both at national and international conferences, mainly on corporate restructuring and insolvency law. Good morning, Giorgio.
Thank you for inviting me.
Giorgio, before starting our short intervention, could you please tell us about some words about INSOL Europe and the benefits of being a member?
Of course. INSOL Europe was established in France in 1985. It is the largest European association for insolvency and restructuring practitioners, academics, and judges. It has got more than 1,300 members, and it facilitates networking among professionals, increasing technical and topical information at EU and international level regarding insolvency and restructuring, and leads the study, evaluation, and development of restructuring insolvency law techniques and practice in Europe. INSOL Europe has a regular contact with the European Commission, as well as with the national associations in this area of law. I would say in a few words that INSOL Europe is the main player in Europe for insolvency and restructuring. We organized two main events, which are on a yearly basis, which are annual conferences. The next one will be in Krakow in Poland on 13 and 14 June of this year. We will deal with preventive restructuring moratoria and their consequences, role and value of insolvency practitioners, distressed company in 2024, pre-PACs, and other topics which are relevant currently in Europe in this area of law. The following event will be in Sorrento in Italy between 3 and 5 October 2024, and the technical program is in progress. I can anticipate that we will deal mainly on restructuring, insolvency, and ESG.
Thank you. On the last 2 years, most of the member states implemented the restructuring directive. Romania also implemented this directive. One new proceeding was created, restructuring agreement, which is a more flexible proceeding with a minimum involvement of the court. It is a proceeding based on negotiation with creditors. Also, the composition agreement has been updated, as you know, under the directive provisions. An evolution of the composition agreement proceeding has been noticed since the directive has been implemented. From June 2020, we have already 112 proceedings, 112 companies tried to access this new proceeding. From the beginning of the year, we have 20 new proceedings and 14 are ongoing. So in Romania, we see an increased interest of the companies for especially the composition agreement. How are the things in other member states?
First of all, I can say that out of 27 member states, 26 EU member states implemented the restructuring directive. Only Poland is missing. As well, the United Kingdom, even though is outside the European Commission, implemented certain principles included in the EU restructuring directive. If you want to have a clear overview on how the directive has been implemented in member states, you could refer to a consolidated table produced by LexisNexis and INSOL Europe, and which is available on INSOL Europe website. I can say, as an Italian practitioner, that Italy implemented this directive, and the number of proceedings is growing, even though it is still quite, especially the composition agreement, concordato preventivo, is rather complex and is still it's being implemented. So I can see that the numbers in Romania are far larger than the ones I can see in other member states, which I assume is in line with a certain culture in Romania, an approach for restructuring when a company is facing a financial crisis.
So we are trying to encourage the negotiation culture. We all together as insolvency practitioners are trying to educate the public and to tell them about the advantages of these new proceedings. But I know that now there are some discussions about a new directive that could modify the insolvency legislation in EU countries and even introduce a new proceeding. We are talking about pre-PAC. Although we saw some intense discussions last year, now it appears that the final text of such a directive is yet far away. What is the status today?
Well, there is first of all, we should say that there is a directive proposal which focuses on insolvency rather than on restructuring. So the idea of this directive is to increase the harmonization process of insolvency laws within EU member states. This is why the directive proposal covers topics as avoidance actions, tracing, asset tracing, pre-PACs, as you mentioned, director's duty to request the opening of insolvency proceeding and civil liability, winding up of insolvent micro enterprises, creditors committee rules and measures enhancing transparency of national insolvency laws. So the Commission made this proposal public on 7 December 2022. The the exam by the Council and the Parliament started. The last official step I'm aware about is the opinion of the Committee on Economic and Monetary Affairs, which was published on 30th of November 2023. I could say that the ordinary legislative procedure is still ongoing, and from what I understand, the new directive could be passed by the end of this year, beginning of next year, and then a 2 years implementation period is expected. However, if this directive is approved, it will be another significant step towards the harmonization of insolvency laws across Europe.
Thank you very much for this update. I think it's a good news that we are closer to have a new proceeding and some updates on insolvency law. Tell me something about pre-PACs, because we don't have such a proceeding in Romania. What could be the advantages of such a proceeding, and what should going on during these proceedings?
Well, no doubt. I think that all insolvency and restructuring practitioners are well aware that in order to keep the value of a business, of a company which is facing financial difficulties or is insolvent high, it is important when possible that the business is sold as a whole. So the pre-pax rules within the directive proposal aim basically at facilitating the sale of the business or a part of it as a going concern within a liquidation proceeding. Of course, the aim is to increase competitiveness so that the sale value is the highest possible, so that creditors may get the highest share of the proceeds. So this pre-pax already exists in practice in many member states. The directive proposal tries to provide some clear rules regarding how pre-pax should work in the preparatory phase or as well as in the liquidation phase. So in order to sell a business or part of it, it is important that the sale process is transparent, follows competitiveness rules. And this is why the process of finding the best offerer takes place according to the expected new rules under the supervision of a monitor, which is a trustee appointed by the court who supervises the process, identifying the interested parties and guiding the tender if a tender takes place. Once if a tender takes place, once the best offerer wins the tender, a court approval of the process which led to identifying the company who won the tender takes place in order to make the process transparent. So as I mentioned before, it is important not only that the business is sold, but is sold to the best offerer within a transparent process. Therefore, once the court certifies that the process aimed at identifying the best offerer was compliant with certain rules, the sale of the business or part of the business is authorized. And this is why I think of course, according to practice, this is the best way to keep value together, to preserve employment agreements, and to grant creditors the best outcome possible from the liquidation of the business. Therefore, I think that if these rules are approved by the Parliament and the Council, I think that the restructuring arena will take a significant benefit from these rules on pre-pax.
Thank you for your intervention, for the update of the restructuring directive, and for the flavor about the new proceeding that we are waiting. So now, have a nice day, Giorgio. Thank you very much.